Okay, so welcome to Real Estate Talk. My name's Neil Peterson, and with me today is Marina Constas. She is a specialist sectional title attorney and BBM law director. And she's also the author of the book Demystifying Sectional Title. Great having you here today, Marina.
Thank you so much, Neil. Always lovely to chat to you.
Absolutely. So we're here to discuss really the state of the sectional title sector. And, you know, we've seen proposals being made to sectional title property owners to amend management rules by way of unanimous resolutions and to obtain independent reviews and also not a proper audit. And, you know, as we earlier said, this could have certainly disastrous consequences, particularly for the sectional title industry and also the property sector. Now, you are an expert in this sector and you've raised the alarm and you've written an article which we're publishing in Real Estate Investor. But before we delve into that issue at hand, maybe just explain to the audience what is sectional title versus all the other categories like individual title, freehold, leasehold, and now there's also a multifamily association that's been formed. And really the fundamental differences of sectional title versus the others. Do you want to maybe just explain that?
Yes, sure. So, Neil, sectional title living is actually prescribed by an act of parliament called the Sectional Title Schemes Management Act, which is prescriptive. It's not a guideline, and that covers body corporates. And what is a body corporate? It would be your townhouse complexes. Sometimes they're within a cluster development, those big blocks of flats. Mostly are sectional title, and what sectional title means is that you own your section, so your unit, your flat, together with a piece of the common property. And before 1971, that wasn't really how property worked. Property worked, you had a landlord who owned the entire building. So sectional title, when it came in, was it was really a surprise to people as to the fact that you can own a section of a building together with maybe an exclusive use area or the common property. But of course, since 1971, sectional title has conquered and is most certainly here to stay. In the country, in Australia, it's called strata title. In the United States, you look at condominium law. So it's a very special way to live, and it's certainly created by legislation.
You know, estimated wise, what size of the market is sectional title versus all the other categories of individual title, freehold? I mean, do you have an estimate in terms of size in South Africa?
Yeah, look, I do know that that sectional title schemes have gone up, in a huge way. There's so many of them, and ultimately you're looking at close to 1 million units now. 1 million sectional title units across the country, definitely over 60,000 sectional title schemes across the country. So I would say they've in certain areas started surpassing freehold. Cluster developments are something different. They're homeowners associations, and they're regulated with a memorandum of incorporation. So they're not under the Sectional Title Schemes Act. They are freehold, but they are within a scheme. So they've also got to comply with the HOA documentation and are also under the regulator of the Community Scheme Ombud Service.
Right, so I think we're probably looking at north of 20%, if we could say, of all property owners, definitely, because it's a big number you've mentioned there. So, and then just how are how is sectional title regulated? Because that's important in terms of our conversation going forward now.
Yes, so there is a great responsibility on the trustees in a sectional title scheme. So your sectional title scheme is made up of the body corporate, which are the owners. The owners are in turn regulated by the trustees. So it's your little committee, your merry band of men and women who put their hands up at those AGMs and say, right, we'll come in and look after. So they're like the prefects of the complex. And then, of course, because it's a prescriptive act, you would have the regulator, which is the Community Scheme Ombud Service, who would oversee disputes. And also your managing agent plays a role here, because whilst your managing agent is not in charge, your managing agent is then in an advisory capacity and will hopefully be able to guide the body corporate in the right direction. the main thing to remember is that the buck stops with the trustees. So when there are problems in that scheme, nobody's going to run to the managing agent for the bad advice they might have given. The trustees have an increased burden of responsibility to understand their role and to understand their fiduciary duty in the scheme.
Okay, so getting on to, your law that you raised in your article. So, what are the potential consequences of amending management rules to exclude audits via unanimous resolutions in sectional title schemes?
Neil, I think we've been seeing, certainly in the last 2 years, we've been seeing an increased level of fraud in complexes. I think where, again, you have lack of money that's around or easily accessible, you might have trustees who are dipping their hands into the funds, or managing agents who might be mismanaging. Certainly quite a few managing agencies have also collapsed and gone into either liquidation or under curatorship. So at the end of the day, because of this, you need better controls financially. And whilst you have managing agents and trustees working together, there are always those opportunities for fraud to come in. I mean, in Gauteng, there was a very, very large estate. I'm not going to mention it, but it was a large estate where the chairperson and the managing agent were in cahoots, and millions were lost in that estate. So I think at this stage in our history right now, we need to be cognizant of what the rationale behind the legislation is. So if you look at Management Rule 26.4, which is the current law around it, it says that body corporate must produce audited financial statements within 4 months of the financial year end. And that is important because before 2016, there was a provision for complexes of 10 and less, or units of complexes with 10 or fewer units. They could get an accounting officer to do their books. Then came the 2016 legislation, and it was decided that all complexes must be audited, no matter how big or small. I've been working with the CSOS on legislation going forward now, which probably would be ready in the next 18 months or so, where they are looking to see, do they still continue with the audits, the proper audits for all complexes? Perhaps we need to go back to where the smaller complexes look at the independent review situation, because let's face it, an audit is expensive. And I think a lot of the times people go to these big auditing companies. The sectional title scheme is at the bottom of their list. I mean, they've got big audits to do, so you're not auditing your sectional title schemes properly. And I've seen lately a lot of smaller companies become specialists, auditors become specialists in sectional title work, because there's a lot of it around. And I think that's fantastic, because you need experts in every field. So the body corporate now, there was this article which came out where certain stakeholders in the industry were saying, well, why don't you amend the rules with a unanimous resolution? Because you can't amend management rules, by the trustees. You'd have to go to the complex and owners and get a unanimous resolution. The unanimous resolution would say that in this complex, we are going to have independent review and not an audit. Now, that is dangerous, because I think that an independent review, whilst it has its place, and there's certainly a lot of people who do independent reviews who are qualified to do independent reviews, but they're not auditors, it gives you a limited assurance. It's a limited assurance. It's not an audit where you've got verification of documents. You've done a deep dive into the completeness of the information that you've received, the accuracy of the information that you've received. I mean, an audit has got a lot of different permutations, and even the Act says that the audit's got to be completed independently of who prepared those financial statements. And sometimes you'll find the independent reviewer has been involved in the preparation of those financial statements. So I think bodies corporate must step up to the plate and realize 2 things. In future, going forward, you need to budget for audits. and find a company that's not ridiculously overpriced. I know there are guys out there charging ridiculous amounts for audits. Do your homework and find good people who are smaller who can do the audits. And secondly, budget for legal fees. So many schemes are not budgeting. I mean, it's a business. The Banking Council of South Africa, Stuart Grobelaar in those days used to say to me, he can't understand why bodies corporate are not treating themselves as businesses. You're a business. You've got asset value. You're looking after a huge amount of money. So why would you not prioritize the two areas where you might hit problems in the road?
So what are those steps that you can be taken? I mean, okay, you've given a few ideas, to ensure there's good governance, transparency, integrity within that sectional title industry. Because, as you say, you've got these very expensive audits. I mean, surely there's a better way that you can look at, and which is probably more affordable. As you say, they've got a budget for legal fees. They've got to have extra, but maybe they can pay less on their audits. So what's the solution? What are the steps that we can do?
Look, again, I think it's very much the start of it is you as an owner, I think you need to ensure that you've got a robust set of trustees, a set of trustees who have some business acumen within the bunch of trustees, because I've seen some shocking sets of trustees who have no knowledge about anything apart from maybe gardening, so you've got to have a robust set of trustees. Your managing agent.
On that point, Marina, sorry to interrupt you, because I think it's quite important. How are those trustees appointed? And, so what is that process? Because we tend to find it's a couple of owners or within the complex. There's normally a property management company that's involved. How are they selected?
Well, unfortunately, what happens is you have an AGM and there are nominations for trustees that have to be in 48 hours before the AGM, and you get people scuffling around asking people who they think might be leadership quality and whatever, asking. I've been at AGMs where nobody's even discussed it yet, so everyone's looking at everyone, and I remember the one lady saying, but what does it mean to be a trustee? And the other guy said, it's nothing much, you just come to a few meetings a year and you mustn't worry. In the meantime, I mustn't say anything at AGMs, otherwise nobody would become a trustee. So at the end of the day, to answer your question, there's no qualification. There are disqualifications. So you can't be a trustee if you've been accused or convicted of fraud or dishonesty in any way. If you've been an insolvent or unrehabilitated insolvent, if you are of unsound mind. But that, I mean, again, that's a bit subjective. So you'd have to have something from the court to say, that person's of unsound mind. And I think that at the end of the day, we need to follow the example of a couple of overseas countries where trustees within 60 days of being appointed as trustees need to do a course. They need to complete something where they are then sort of qualified to act. Because then if they don't do that, then they're automatically disqualified. You have to have some sort of qualification. And maybe that's something that the Community Scheme Ombud Service could be looking at as well.
Yeah, well, you could certainly lobby for that, because I think, you've written the book, Demystifying Sectional Title. I know you've done a lot of training in that, and I think you're certainly playing a role in that. So in an ideal world, I mean, why that should be a prerequisite.
Definitely. And it's not difficult. It's not difficult to put something into the rules. I'm not sure why it's taken us so long, actually, to do something like that. We've got to, compliance is everywhere. And when I go to talks and give talks to managing agents, they're always moaning and saying, they're trying to put obstacles in our way of doing business. And why is it so hard? You got to know this, you got to know that. Welcome to the real world. You've been spoiled up to now. That's what I tell them.
Absolutely. So, Marina, in your experience, I mean, how prevalent is fraud? Now, I know we spoke a little bit about it just initially when we were discussing, within sectional title schemes in particular, and what other measures, given obviously what we've just said now, can be implemented to mitigate this risk? Because, okay, you've mentioned a few ideas and stuff, but what else can we do to mitigate the risk of fraud?
Well, there always have to be checks and balances. So you would never be able, for me, I don't think you should have only one trustee signing off documents with the managing agent. I think you should have 2 signatories. And obviously, I think that bank account should be seen by trustees. The money is going in, the money's going out at the trustees' meetings. They should have a look at that. You know, at the end of the day, there's also obviously the debate about accounts and trust accounts. With the larger managing agents, you often have many body corporates falling into one suspense account of that managing agent. And it becomes tricky because monies get mixed up. And I mean, I've got clients who do operate that way. And they will tell you it's absolutely above board. And for the most part, it is. But I can tell you, Neil, if I lived in a sectional title complex, which I don't for obvious reasons, I would insist on my body corporate having a separate bank account. And the managing agent managing that body corporate, but I would like to see the money, what's going on in my own bank account, quite frankly.
I mean, you know, I mean, I've had a personal experience as well. You know, in Johannesburg, actually, Midrand, there was a development. I also won't mention the development, but the you know, the property manager ran away with all the levies because she used to collect the levies for a number of the owners on there, and she disappeared. And she was doing this for more than 2 years. And, you know, so if there were those kind of checks and balances, as you say, sort of in place, we could have avoided that. So maybe can you provide some insights into the historical context of audits in sectional title schemes, and, you know, the changes that have been brought about the Act, the Sectional Title Schemes Act, because surely that must play a role in that.
Look, I think, you know, there's always been fraud. In the early days when I started practicing in sectional title developments, there was one very large managing agency who was a client of mine. And as a young attorney then, I was so shocked and horrified that this could have gone on under the noses of the owners. And being placed under curatorship, the pain and suffering really that it led to for owners was incredible. So it's not as though it's a brand new thing. I think the extent of it has increased due to the economic situation that we find ourselves in. And I think that when you've got a complacent set of owners who just trust trustees, you know, he's been a chairperson for 30 years. He does a good job. We see what he's doing. That's when the problems start, because that's when, you know, you're not receiving the correct invoices for monies that have been spent. And managing agents, you know, there are some, mostly they're great, but there are some crooks out there who are looking for ways to skim money off the top. And they're also looking for ways to get kickbacks because the managing agents have very low margins. So maybe if you give the paint job for the complex to X, Mr. X will give you a kickback and that type of thing. And that's the thing we don't want to see in complexes. Those types of things, I know if you speak to a couple of the auditors that I deal with, there's definitely been an increase in that. Definitely been an increase in that.
Right. So I think you're playing such an important role there, Marina. And I think that, you know, certainly in this particular category, because I mean, in any investment, doesn't matter what it is, you know, the underbelly is that there are problems, but I think you're trying to deal with them. But maybe how can we, the stakeholders, you know, we're talking about owners, trustees, managing agents, investors, how can they collaborate themselves? Because you're certainly driving this, it seems, and trying to get the change to address these challenges and really uphold the standards of sectional title governance. What do you suggest could be done on that level?
Well, Neil, I think since I started again practicing law in this space, I think a huge amount has happened. So you've got your National Association of Managing Agents, where the messages are good. The messages are professionalize the industry, and managing agents themselves are starting to become professionalized. You've got the PPRA, who at some stage when they're ready will have the education for managing agents as opposed to treating them like estate agents, which has been happening in the past. So already those things are very good. There's a lot more information available to read. by owners. Owners are becoming more sophisticated. So they're asking cleverer questions. I'm finding they're wanting to find things out. I think younger people need to get involved in their schemes as well. You know, if I have a free sectional title week, which I hold twice a year here at my office, for people to come and just consult with me for half an hour, it always looks like a retirement village is coming to visit me, you know. So you need the younger crowd in the complexes to also become involved. I would say that. Owners must try to attend meetings where they can. And I think the virtual meeting space has given you an opportunity not to leave the comfort of your home to be able to attend an AGM. I think that's very positive. And managing agents professionalize, trustees need to be trained, and that must be a priority. And owners must know when to get rid of trustees who are not actually producing good results for their schemes.
Wonderful. But it's been great chatting to you, Marina. Marina Constas. She's a specialist sectional title attorney and BBM law director, and also the author of the book Demystifying Section Title. Thank you very much, Marina. Nice chatting to you.
Thank you, Neil. Thank you.
This is Neil Peterson of REI signing out. Thanks very much.
Thanks, Neil. Thank you.
Cheers, go well. Cheers,
Bye.
Marina.